Today, we're lucky to be joined by the founder of the largest IP firm in America, Doug Henderson. Thank you so much for joining us today. As you know, I started my career here, so thanks for having me back. I really appreciate this opportunity to talk with you about your career. I just wanted to start. Do you remember when you first realized that Finnegan was going to become the largest IP firm in America? What was your reaction to that?
I don't think I was very surprised at that point. We had been growing pretty dramatically, and we knew that we were getting up there. And the size of the firm was not something we ever really wanted to be the calling card of our firm. We wanted it to be that we were the best that you could be, and that people would come to us for that. But the firm, when we started out, had several meetings in which we decided how big we were going to be. We were going to be 15 at one time. Wow. And then we were going to be 35. And I think at one point we might have even said, well, we're going to be 100. But we were trying to stop it. Yeah. We didn't want it to grow. But none of us could ever turn down the business when it came in. Yeah. So we would laugh and say, you know, you're supposed to be turning down, but oh, it's such and such a company. I mean, you can't turn them down. Yeah. So it kept growing. So I wasn't really surprised by the time somebody published that we were the largest. Yeah. I don't know where that stands today. It gets a little confusing because some other firms have people that aren't in the IP area. Yeah. And then the question becomes whether a copyright attorney fits in. So it's a little blurred these days, but certainly at one point we were considered the biggest, and I think it's still one of the biggest.
Yeah, definitely. So we'll get back to that, but I really want to talk about your life first. So I know you grew up in Pennsylvania, I believe. Is there anything from your childhood that stands out about that shaped who you are in your life?
Well, there are lots of things, I think, in my childhood, but when I was very young, my dad got me involved in his business. He was a furniture manufacturer's representative in my later years, but before that, he was a plant manager where he manufactured mattresses, and I would go with him on Saturdays to look at the big machines and see the people and what's going on there. And that gave me a sense of industry, how things work, the processing of projects. So I liked that. But after a while, he decided to go out on his own as a manufacturer's representative. He represented a number of very prominent furniture companies. And I would work with him on that. The first thing I ever did for him was he had me come to Chicago when I was 8 years old, took the train all alone, and would sit in one of his spaces, and that's where they had furniture displayed for buyers to come in, and he might be in another space, and I was to call him if one of his customers came in. So it was a good experience for me. And the nice part of that, and most of what else my father taught me in those days, was I got very used to dealing with business people. The presidents of those companies would be there. You talked with them all day. The customers were often big companies and certainly successful businessmen. So I sort of grew up talking to those people as being my dad's customers, but people that I wasn't intimidated by. I didn't know I should be. And I think that helped me later on. And when I got to be old enough to drive, I had a car, and my dad let me call on all the small cities that he didn't call on. We had the territory he had was Pennsylvania, West Virginia, Ohio, parts of New York, Michigan. And I would go out and call on the small towns. He called on Pittsburgh, Columbus, Cincinnati, Cleveland, Detroit. But I was calling on Altoona, Tyrone, you name the small towns. It used to be, when I first was doing that, I knew somebody in every small town in western Pennsylvania, West Virginia. But because I knew the furniture store dealers. But that was a great experience for me also. I was out on my own. And I think I learned something there that helped my profession, in that these gentlemen all knew so much more about what I was selling them than I knew. And so I knew enough to go in and show them my pictures, show them the samples, and let them tell me what I should be saying. And many of them would. They would say, the way you want to do this, Doug, is this way. And I found that works in life in general. I often tell young lawyers that when they go to the clerk's office, don't go down and pretend you know what they're doing. Go down and say, hey, I really don't know what's going on here. I need to file this paper.
That's very helpful.
Tell me how to do it.
Yeah. Did you ever think you were going to do that as your whole career, or did you know you were going to do something else by the time you went to Penn State? Or?
Well, I did think at one point that I should do that for a while. I was about to be married when I was in college, or right out of college, and my wife and I discussed it. And I had some other options, which we can discuss later, but we decided, try the furniture business full-time. You'll get it out of your system. If you like it, it's great. If you think you can do it, you want to do other things, it'll be easier to do it later. So I went with my dad's firm for a couple of years and did basically what I would do in the summer. And I even would do it during school. I took the week off before exam a couple of times to go to the furniture market. But it was important, and it made money. So that helped us. But if you're interested, when I was in high school, I was on the student court. And loved that. And thought, gee, wouldn't it be great to be a judge? And much to my surprise, I learned you couldn't just become a judge. You had to be a lawyer and do some other things. So I thought I wanted to go to law school and maybe take pre-law. But my dad, who was a very successful man, but was also very strong-willed, had his own ideas. And I had an amazing opportunity where my high school principal took three of us down to the Duquesne Club in Pittsburgh. And we had lunch, and then three gentlemen came and sat with us a while and talked to us. And they said, if you want to go to college, we will pay. If you want to go to one of our schools, you have to get admitted, but we will make sure you can afford it. And they were from Yale, Harvard, and Princeton. So I went home and told my dad I was going to Yale. And he said, you will not. Your sister's going to Penn State. I'm not going to drive kids to two places. So I ended up going to Penn State. And I then told him I was going to take pre-law. And he said, you're not going to take pre-law. I want you to go to school and learn something you can earn some money at when you're through. So you can take any engineering you want. And so I ended up taking engineering. I took industrial engineering, which I kind of liked because it was what I had done a lot of, walking through my dad's plant when I was a little boy, seeing how things operated and what was going on. So I enjoyed that aspect of being a kid in a plant, and I thought it would be fun, and it was fun. I still like that. It's always great when someone says, we want you to come and see our plant. So we did a lot of that, even in the IP area. But I did okay in engineering school. I didn't graduate number one. My advisor called me one day and said, when I was a freshman, and said, do you realize your aptitude for engineering is very low? You shouldn't be in this. And I explained to him that he might have known aptitude tests, but he didn't know my father. I was going to get through engineering school, which I did. But he later called me one time and said, you talked about wanting to go to law school. Believe it or not. Was this after you graduated? Or? No, this was when I was still in school. And he said, why don't you come over here and meet a guy named Rothermel? Mr. Rothermel was with the patent office. In those days, they were in need of examiners, almost desperate need for examiners. So Rothermel was a really nice guy. I enjoyed meeting him. And he explained that they were going to have law school classes in the patent office from George Washington University. You could go to law school during the day. Sounded wonderful. I was a junior at the time, and I thought I was going, as my advisor said, go and find out what this is all about.
Yeah.
Probably 2 months later, I got something in the mail. I was appointed an examiner in the United States Patent and Trademark Office as a junior. And a lot of people at Penn State heard about that because none of us knew whether we could get a job when we graduated. Typically, people didn't get an offer then. So this gets back to the story of my discussing with my then fiance.
Yeah.
Should we go to the patent office or should we go with my dad? And I went with my dad. But interestingly, a lot of people from Penn State applied to the patent office at that time. And there's a lot of them still in the business. But, so that was a little bit of history of how I got involved in all of this.
And then you finally decided to go to law school. Was there some particular reason? Did you finally get your fill of the furniture business, or?
No, I thoroughly enjoyed the furniture business, enjoyed the people. There was a bit in it that, you know, my dad was very successful.
Yeah.
Everybody knew Art Henderson. And so when I did something good, everybody sort of said, yeah, I expect that. And if I screwed something up, everybody said, oh my gosh, Art Henderson can't do this. But that wasn't a big deal.
Yeah.
But I only tell you that because it's something I later realized I had in common with Mark Finnegan.
Yeah. So let's talk a little bit about him. So obviously you started Finnegan Henderson with him, and he went to work. He started his patent law career at Morgan Finnegan, which is a very old IP firm. Can you tell us more about what was his relationship to the Finnegan of that firm and why he ended up not staying there? Because I think
I alluded a little bit to it, but let me tell you about Mark. He was an amazing guy, had a wonderful capacity for people's names and loved people. And people loved him. At 30 years old, he had snow white hair. And he was a West Pointer, as his father had been. And he had big, broad shoulders. I used to kid him that he had to have his suits made because if you got a coat big enough to fit him, they would have to cross the pockets in the back of the pants to have them fit him. But he was a good-looking, very athletic-looking guy. And he had been... He graduated from West Point. He got married, thought he was going to take his bride to Japan, and they were going to live comfortably for several years. They drove across the country to Seattle, where they were to take a boat, I guess. And halfway across, the North Koreans crossed the 38th parallel, started the Korean War. Yeah. And to make a long story short, he had to send his wife back. He did go to Japan, but he became one of those that made the Incheon landing, which is before your time. But General MacArthur was being pushed off the peninsula, and he decided to get in behind the North Korean lines. So he went up to Incheon and brought in an invasion force and got behind the lines. And would have won that at that time, except the Chinese then came across the border and pushed them down again. But Mark made that Incheon landing with MacArthur, and he would have fun stories to tell. He was an engineer in the Army, and his job was to go out and make sure that the tanks could go over the bridges that were out there, and also occasionally he would be in enemy territory. He said it was always scary when the villagers come out and said, "You've liberated us." And they said, "No, we haven't." He wanted out. But anyhow, he was quite a guy. And after the war, they sent him to a law school at the University of Virginia. And then he went back to Japan, then to live the life he thought he lived before. And, of course, he loved Japan. So that's a little bit of his background. You'll be interested that his father was a patent attorney before him. And his father was in the patent office and was working with a fellow there named Hobart Durham. And they had a great relationship. But George Finnegan, who was known as Geordie, was interested in marrying a young lady named Morgan. Yeah. And her father was a patent attorney in New York. Yeah. And so when they got married, his new father-in-law insisted he come to the firm, and he said, "I'm going to bring my friend Hobart." So it became Morgan, Finnegan, Durham, and Pine.
Yeah.
Pine came along a little later, but so Mark was actually a third-generation patent attorney.
Wow. Yeah.
And I like to tell the story, which is probably only 50% accurate, but Morgan was a patent attorney back before they had income tax. And so he made a lot of money and was able to keep it. And even though Mark's father was a terrific patent attorney, built that firm up to be one of maybe the premier patent firm in the country.
Right.
He never had as much money as his wife did because she inherited her father's money. Yeah. And it was all because of income tax. Yeah. But so Mark went with that firm when he came back from being the patent advisor to the occupational forces in Japan. Yeah. And he did well. He was a smart guy and a likable guy, as was his dad, of course. And they had a number of good cases, and he liked to tell the stories that one new client came in with a great big case against General Foods, and the client asked at the desk for Marcus Finnegan, and when they heard about the case, they said, "No, you want George Finnegan." And they said, "No, we want Marcus Finnegan."
That's great.
And they knew that Marcus Finnegan, for another client, had done an analysis of some not Georgia Pacific, I want to say General Foods patents.
Okay.
And anyhow, so Mark ended up with that case, and he did a lot of other things there. Yeah. But he found no matter what he did, they said, "Well, yeah, but he's George Finnegan's son." And if he screwed anything up, they said, "Gosh, even George Finnegan's son can't do this." So we would laugh about that. Yeah. We'd had similar experiences being with very successful fathers. But Mark, I don't know how much longer you want me to go on with this, but I can tell you a little bit about Mark's getting to where he was when I met him. Right. His father's firm was growing, and the family, in my estimation, treated the firm like it was a local hardware store. Everybody presumed Mark would take it over. Well, he had like 18 partners at that time. So, any rate, Mark got a call one time from a law firm in the city, and it was then Irons, Birch, Swindler, McKee.
Yeah. In Washington, right?
In Washington, and they said, "Can you find any litigators for us? We've got work coming out our years. Do you know anybody?" And Mark thought about it a while, and he thought, maybe it ought to be me. So he came down, and
how did his dad react to it?
Well, I think his dad was fine. Maybe would like to have seen him stayed, but he realized that Mark had a lot on the ball, and he could feel the tensions in the firm as well. So his dad supported him and continued to help him with this big case that he had whenever Mark wanted help. But the interesting thing was Irons Birch had all this litigation, and Mark came down and he brought his own clients. Yeah. He brought this River Brand Rice Mills v. General Foods. That was a major case. And he also had United Technologies, patent prosecution work, and opinion work. Right. So he had a lot of work. Yeah. And so Irons Birch soon found that it wasn't helping them. They needed Mark was there. They needed more help. Yeah. And that's actually how I got my job, because I was then a clerk at the United States Court of Claims for Judge Lane. And they needed somebody that knew how to litigate to help them. And even though I was just out of law school, I'd spent a whole year watching 6 patent cases being tried, and we decided 6 patent cases during that same period. Interestingly, that of the 6 cases we decided, only one went against the patent owner, and that happened to be Mark Finnegan's client, Connecticut Valley Enterprises. But you might know this. Judge Lane, doing my year with him, decided the Adams Battery case, which went to the Supreme Court. Oh, wow. It was one of the 3 cases that were decided on obviousness. And it was the first case, it was the only one of the three in which they found the patent valid and infringed, which affirmed Judge Lane's decision.
Good.
And that was the first time the Supreme Court had found a patent valid and infringed in 25 years.
Oh, wow.
The previous case had been an AMP case that dealt with, I think, the way foods were slid up to the counter.
Right.
So that's a little background on that situation. I interviewed, I can't remember if I told you online or not, but I interviewed with Mark and Bill Beckett.
Okay.
And at the time, Mark wasn't...
So Bill, that was at Irons Birch?
Yes. Yeah. I interviewed several other firms in the city, and it was really nice interviewing as a law clerk rather than looking for a job when you're just out of law school, because a lot of firms were willing to talk to you. But I took the job there, and Mark and I became fast friends. He originally wasn't speaking to me.
Because of that case you lost, or?
Because of the case he lost, that's right. And but he had a case in Texas, and he had been looking for a way to take the appeal. And if he lost the oral argument, it was really a question of whether antitrust claims could be joined to the patent case or whether they ought to be severed.
Yeah.
And I helped him get the right decision there, and he came back and liked me. And we became friends ever after.
So Irons Birch, which is now, I believe, Banner Whitcoff, but you and Mark Finnegan ended up leaving that firm and starting your own firm. How did that come about, and why did you decide to do that?
Well, Mark was the world's best associate. He had brought all his own work.
Yeah.
The senior partner in the firm was working on his case. Bill Beckett was working on his case. I was working on his case, this River Brand Rice Mills case. And Mark, of course, had prosecution, and he was a hard worker. 3 days a week he worked until 7 or 8 o'clock at night, no matter whether he had work or not. It had forced him to.
Yeah.
And he billed 5 times his salary.
Wow.
And, of course, he's had these great clients. So I keep saying I've never known an associate to be that good. But at the time, the firm was having some problems amongst themselves. And they couldn't agree on how to split shares. And so they couldn't make any new partners.
Yeah.
So the first year I was there, I talked with Mark, and we didn't make him a partner. And I think we were all the associates were astounded. And then the next year, when it didn't happen, we just discussed you had to do something.
Yeah.
And I think I was more the entrepreneur than Mark was.
Interesting.
I sort of had to talk him into doing this.
Is that because of your dad, you think? That you...
Maybe some of that's right, my background was I wasn't afraid to get out and try something on my own and see how it worked. And Mark had sort of a more secure background, I think, in that sense. But he was willing to do it, but I think he was always had trepidations about going out on our own. And I kept urging him to do it. I said it wasn't fair. So we did leave. And we decided we were going to set up this law firm, and we discussed it. In those days, most law firms were positioned close to the Patent and Trademark Office in Virginia.
Yeah.
But those were firms that were doing what we called associate work. They would do work for out-of-town companies. They'd go to the patent office, run searches. They might interview examiners and all that. So it was convenient to be there.
Yeah.
And we were willing to do that. I had done all that because before I was at the court, I worked for Swift & Company when I was going to law school with a fellow named Ford Faribault.
Okay.
And,
another named partner of the firm.
Yes, that's right. And actually got to know Art Garrett during that same time period. But so we were prepared to do anything, but we wanted to do litigation, licensing, full service work.
Right.
So we opened in Washington and not in Crystal City. We believed that you are what you think you are, and we felt like we were good lawyers. And So we felt like, all right, set yourself up that way. And we took the top floor in the Channon building, which is still here in town, across from the Army-Navy country, the Army-Navy Club. And it was where all the prestige firms were in those days. Our neighbor on that top floor was a fellow named Clark Clifford, who had just been the Secretary of Defense, and had been Truman's White House counsel. So he had taken the backside of the top floor, which happened to overlook the White House, which left the front side of the top floor open. We overlooked Farragut Square, had corner offices.
Very nice.
We'd set it up very nicely. And, we did everything first class. We had a beautiful library. We had beautiful shelving in there. We had a complete federal library. We went out, and one of my clients then, when we opened, had the Boeing Company amongst some others, but they were a good client. And my client said when we did all this, said, boy, you're going down in a blaze of glory if you go. But it worked. Clients came to see us, they liked us, and gave us work.
Besides the broad practice that you were going to have, did you have any kind of vision or goals for the firm when you were starting it?
To be a full-service law firm. And we had lots of things that we discussed in those days, and how we wanted to run our firm, how we wanted it to be different. Because there was just the two of us, and then Ford came very quickly, Ford Faribault, we were able to do what we wanted. I mean, we didn't have to ask somebody else. And because all of our clients were relatively new, we didn't have any clients that had been ours for 30 years. They had been ours for 5 years or so, and or less in my case. And we kept thinking, if we make a mistake, the same patent counsel who decided that he was going to leave somebody else and give work to us because he thought we'd do a better job, we'll move it somewhere else. And we worried about that because everybody has blind spots. I mean, at some point or other, you're going to miss something. And so we said, let's do this. Before anything goes out of the office, let's both look at it. And that way, if there's a blind spot, hopefully we'll catch it. And it became known over the years as second attorney review.
Oh, wow. So that's how that started.
And it wasn't like this was some management thing you could study. Nobody, to my knowledge, was doing that at that time. And we only did it because we were a couple of young guys that didn't dare lose a client. And it worked out very well for us. So we perpetuated it. And we're pleased to see many others adopted it. The patent office eventually had adopted the policy, and they called it the Two Eyes program. But many law firms and corporations used it after that. And we wanted to be good writers. We worried about being good writers. We read everything one last time before it went out. We were always afraid that in revising something, you'd leave a line out or something like that, or some earlier version would end up coming out in some way, particularly as we got computers. That got to be a bigger risk. So our rule was, before it goes out, you got to read it one last time. And I can remember, I think we all did this in the firm for, as far as I know, they still do. You're sitting there at 3 o'clock in the morning, you finally got this brief done, and you're sick of it because you looked at it 6 or 8 times, and you say, no, I owe my partners, I will sit here and read it one last time.
It's a free lesson.
So we did that. We did that. And we had some benefits. That's first big lawsuit we had was Mark's lawsuit. I had some litigation. Mine was more in the interference level with Boeing at the time, but we eventually had litigation for Boeing as well. And we had good opponents. And there wasn't the Rambo lawyering you see today, but even then, there were people that were tough to get along with. And we decided we were going to practice law as ladies and gentlemen of the bar. I had the ladies. There weren't ladies then, but as soon as ladies come into the firm, we said, this is what we're going to do. We're going to win cases by good lawyering, not by trickery or fighting or screaming.
Right. I remember when I was at Finnegan, there was a lot of emphasis that the clients are really the firm's clients and not any individual partner's clients. Do you remember when that idea came about, and how did you implement it in a way that partners were willing to share their clients with everybody else at the firm, I guess, the clients that they brought in?
From day one, that was the way we did it. We were working on this big case together, so that was sort of natural.
Yeah.
But Mark had, as I say, he had United Technology, I had Boeing, I had Louisiana Pacific, and we discussed the fact that law firms had trouble because people were stealing each other's clients and were not willing to let somebody else work on their work. And they would hoard the work because they were afraid somebody would steal it. We knew that in those days. So we said, let's just do away with that tension.
Yeah.
And we'll just, all clients and firm clients at the end of the year will be fair with each other. And we did that for many years, and we kept that going. Now I think a lot of firms are going that way because it keeps you together.
Thinking back, is there anything you would have done differently in the beginning of your firm, or maybe in the first 5 years of your firm, in retrospect?
I don't think so. We liked what we were doing. We brought in good people. Mark had an idea that he never wanted to bring anybody into the firm. You would have been in this category, but he didn't feel like going down after work and having a drink with. And not that they had to drink, but he didn't want people that were brilliant but not very nice to get along with. And so that was very important when we started, and it helped us build up with great people. I mean, I still enjoy all those people.
Were there any difficulties that stand out to you, or anything that surprised you in a positive way when you were starting in the firm that maybe was easier or more enjoyable than you?
Well, I think when we opened, Mark, of course, had all this history of his family being into business, and he had decided that if we hung out our shingle and did good work, work would come in.
Yeah.
And so we had good work, but we kept thinking, when's the work going to come in? Yeah. And we realized quite quickly that you had to get out and meet clients, that they didn't come to your door. You got to know them, and then they would, send you work. And back because I was in the furniture business, my whole business had been going to call on clients.
Right.
And so we decided we'd call on our contacts, people we knew who were hoping to send us work. We'd just drop in to see them and say hello and tell them we're in town. Let them know, even though we were in Washington and they were in Pittsburgh or New York, we could easily get there. We came and visited them. And that worked amazingly well. We had a number of them say, I've never, ever had a lawyer come and visit me before. And we weren't charging them. Yeah. We were just going to see them. But it was the way we developed clients. And sometimes it took a while. And but I can remember one trip we made, we visited 5 different companies. We knew the people. It wasn't cold calling.
Right.
But we just had fun with people, and we made them better friends than they had been before we went. We got work ultimately from all of them.
Great. That's great.
And we had one company that we never visited, but I kept hearing, and Mark would hear, they're telling people they're going to send us work. And we kept thinking, oh, this is really great. I think it was like 12 years later that they sent us some work.
So if you were waiting and sitting around then...
Yeah, it wouldn't have worked. That's right.
What was your pitch back then when you were visiting the clients, or were you not?
It's interesting. The pitch in a way was, give us a try. Give us some project. We'll work on it. But I think the real pitch was, we're your friends.
Okay.
And we want to be your friends. We'll be fun to work with, and we will make you look good.
Okay.
That basically was it.
Unfortunately, Mark Finnegan, he passed away in 1979. Can you talk a little bit about that period of time? Were you worried about the future of the firm when that happened?
We weren't. You may know how many people we had at the time, but we had a number of partners, and we had brought in a lot of solid people. Several of them had been partners in their own law firms. Again, they were people we liked to be with, and some of them had been with the same firm, with Ironsburg, Swindler, McKee, which was an incredible firm. Yeah. And they were really good lawyers, had a lot of good business, and they taught you good strategies and how to be a good lawyer, how to do thorough research, and how to be careful and not make mistakes. They emphasized that. So we had that kind of a background at that time, and so we were just trying to do that.
And I know Don Dunner, he actually joined that same year. Can you tell us a little bit about how that came about?
Well, yeah. When you'd actually asked me, and I slipped over it, whether Mark's death made us worry, we weren't worried. Yeah. We felt very confident we would continue. I mean, we had lots of clients that weren't Mark's clients at the time, but we all worked together, and because we didn't, quote, have clients, other people worked on these clients that had come in. So we weren't worried, but not unsurprisingly, maybe our competition or even some clients would say, are they going to survive?
Wow.
And I had to make a trip to Japan. Mark was mostly doing the Japanese work in those days and made the trips. But they wanted to see me. Yeah. So I run around and visited all these clients in Japan, and it was a fun thing to do. It was a really busy time for me because I had other cases to keep going, but it was important that we meet these clients because Mark had really good ones. So we got through that in a big hurry. It wasn't a real problem, but we appreciated it. And a very significant thing happened. Mark had been good friends with a man that was the patent counsel of Toshiba. And Toshiba was a forward-thinking company, and they wanted to open an office in the United States, but they wanted to do it in a law firm. Yeah. So they had picked our law firm, and they were working toward it. They were to open in April, and Mark died right about then. Okay. And I think I first made the trip to Japan, and then they said yes, but they said yes right away, that they were going to continue to open their office. It wasn't like it took me going there. Yeah. They were moving ahead and were going to open their office. And that helped us because, particularly in Japan, all the other companies said, they must be okay. Toshiba's going to continue to open their office. And that was unusual. I don't think any other companies had offices like that. So every other company was looking at Toshiba. What are they doing? Yeah. So I always admired that in them. And we've been friends with Toshiba ever since. And right down the hall today, they still have an office in our office. Yeah.
So I guess can you tell us a little bit about how Don Dunner ended up joining the firm?
Don was a friend. I knew Don. We knew most of our partners before we brought them in. And a couple of times we'd talked about Don Dunner coming in. And Don was doing very well. He was on the ladder at the AIPLA. He spoke a lot of places. So we knew him. We knew he was a good lawyer. But it never came to anything. And finally, one time, I think Jenny Sue Dunner, who was Don's wife, said to Betsy Finnegan, I think Don would really like to make a move. So Mark told me... Where was
he at the time?
He was at Lane, Aiken, Dunner, and Zeem, the main partner. Yeah. And so Mark and I talked about it, and I think we met with Don, but we both knew him. I mean, it was like meeting somebody you knew already. And it was a bit difficult in one respect. Even though we'd had other partners in law firms come with us, one of the things we decided at the very beginning is everybody had to learn our culture before they became a partner. Right. So Don comes in as an associate. Here's the named partner in a law firm and them to be president of the AIPLA. And he was coming in as associate, but he finally agreed to that. Yeah. And so that was a year before we made him a partner. Yeah. And that was in the plans all along. So it just was coincidental that Mark got really sick that year. And it was very nice from our standpoint because it was a real nice plus to have Don in the firm.
Yeah.
But it wasn't like we went out looking for Don. And we liked him. He fit in perfectly and was a great partner. So it was an idea. It was a tough year for him that first year. He and I sometimes sat down and wrung our hands about when's this going to happen. And but we had agreed with him that after the year, we would even put his name in the firm, which took something else that I always thought was a long suit in our firm. Brian Brunsvold, who was next in line to have his name in the firm, agreed without even any arm twist. That was the way we were in those days. Right. It was for the good of the firm. Everybody said fine. We worked on a consensus basis. We didn't take votes. We just until everybody agreed. And I mean, the joke would be when one person was holding out, we would say, well, how many points is that worth to you to hold out to that point? Oh, well, if you're down to that, all right, I agree.
What was your favorite part of your work? Was it the legal work itself, managing the firm, or developing the client relationships? Is there anything that you
I liked it all. It was all fun. If I had to pick one of those, I'd probably say I loved getting together with the clients, meeting clients, bringing clients in. But I enjoyed the practice of the law. It was fun to be in court. It was exhilarating, demanding. And managing the firm was a lot of fun, although when we first opened, we were managing the firm, buying insurance, buying books for the library and everything, and still trying to keep our practice going. But it was fun, so we enjoyed it all. If I had to pick one, I might say I enjoyed client relations.
I think you talked about it in the beginning, but you never set out to build this giant firm. But was there a certain inflection point when the rapid growth started? I know. And were there any difficulties when it started going from 50 to 100 to and so forth?
Well, it used to be that when there was a partners meeting, we just quietly went out. Nobody ever knew we ever had a partners meeting. Well, when the firm got bigger, that got to be more difficult to do. And there were things like that. There was the need to have more space. And during those years when we were growing, we had 3 different buildings. We had office space over on 18th and K. And so those parts were difficult. But, no one said, absolutely we're not. We did say sometimes, absolutely we're not taking more clients, but we always did. But it never was a serious problem. We just loved the fact that good clients were coming to us. And so that was valuable.
And how did you make sure the quality of the work was maintained when you're hiring, let's say, the 150th attorney and so forth?
Well, we did a number of things. One thing we did, and I don't think any other law firm was doing it in those days, we hired trainers. It used to be when I was going to law school and Ford and I were at Swift & Company, they had corporate trainers that taught us patent law. And so most of the big companies had offices here then, DuPont, Gulf Oil, United States Steel. So that was how we learned. Well, those companies all pulled back those offices during one of the recessions, so there was nobody training people anymore. So we were hiring people that didn't have training. Some came from the patent office, needed less training than others, but some came with no experience at all. So we hired trainers who were usually corporate guys who were getting ready to retire, and they decided they'd retire and come with us up counsel, but they would teach our people.
That was great.
And they did a good job of making sure of that. And I suspect you came to one of my lectures, but I would have a lecture with the new lawyers after they'd been there 6 months, and would go over what I used to say were the hallmarks of the firm, and insist that they follow those. And second attorney review was always a tough one because everybody felt like, well, I'm a real lawyer. I want to be able to do this on my own. This is not because we don't trust you. We just don't want to make any mistakes. And so those were the type of things we did. And then I always met with the new partners and had a similar meeting. But urged them to keep the spirit of the firm going the way it was. Now they were managers, so to speak, of people, and we wanted it to be a happy place to work, which for most of the time it was.
I want to shift a little bit, but I'm thinking there's still large firms that are being run by their founding partner, and I'm thinking of Kesavitz Benson because it's been in the news a lot. But I've also read that transitioning to a second-generation partnership is the hardest thing any firm has to do. When did you start thinking about it, and was it hard for you to do since you did take that initial risk to start the firm and put in all that hard work in the beginning to make it happen?
We didn't really think about it that way. What I think happened is we had new blood coming in, younger partners, some of whom didn't have the same entrepreneurial spirit that we had, but were still very good lawyers and nice people to be with. And occasionally somebody would say something like, what's going to happen when you guys leave or retire? And there was a time when I think there were 4 or 5 of us that had 90% of the clients. And I say had them, we had them in the sense we were the ones that maintained them. We went to visit them, we called on them, kept them there. So 2 things happened. One, we got everybody developing clients and working to get to know clients and so forth. And we decided, you guys can run the firm for a while. Go ahead. I don't think it was ever any hand-wringing thing. We just said, who should we let do this? And I think one partner came up with some what turned out to be wild ideas at a partners meeting. We said, okay, let him try it.
Did you remember any of those ideas? Or
Well, I think at that time he was thinking, we have people that are making bigger contributions than others, so let's go to you eat what you kill. And we had so many partners that had been in other firms at that point, they kind of stood up and said, you never want to be in a firm like that. But we said, you go ahead and try it. But not with that in mind, but go ahead and manage the firm. And so we were very successful in having that done. And I don't think anybody really thought this was some dramatic thing.
Right. Did anything surprise you about the direction of a firm once you let other people manage it and after that?
Well, not so much that as the firm got bigger and bigger, it couldn't be as flexible as it used to be when we would just sit around and say, don't worry about it, we'll take care of it. And people would start to say, other firms are doing this, other firms are doing that. Consultants would come in. And we didn't pay any attention to the consultants when we were early on, but when you get to be a really big law firm, you've got new pressures and things to do. And so we moved a little more in that direction. I think today the firm is more like other big firms than we were as a small firm like other small firms. And I think that's just the way it is if you get to be a big firm.
And I guess that brings us to the next topic. I want to talk about the legal industry as a whole. I mean, talking about big law firms, does it surprise you how similar they are in terms of, it seems they have the same, they recruit in the same way, they have the same associate compensation structure, the same kind of marketing campaigns and initiatives. Does it surprise you how uniform they are, or is that?
It's not a surprise, but it was what I just said to you. I think that you get to be big, you pay attention to what others are doing, and you compete with these others. So they force you at sometimes. There were a number of times when we didn't feel like we needed to raise associates' starting salaries, but everybody else raised associate starting salaries, and we wanted to get the best and the brightest, so you sort of had to match it. And in turn, you had to demand more of them, which got us into the cycle that most law firms are in today, where if they're making a lot of money, but they're expected to work really hard.
How has the IP, specifically the IP legal industry, evolved since the time you started practicing or started Finnegan Henderson?
Well, it has changed, and it's swinging back and forth a little bit at this point. But when we opened the firm, when I first got into business, very few patents were held valid and infringed. The courts around the country were sort of negative on patents, and indeed a lot of economists were writing articles that said this is a monopoly, this isn't good, this is hurting industry. and holding things back. And so the patent system wasn't anything like it is today. It wasn't as valuable. There weren't other law firms trying to get into the business because they thought we were kind of strange lawyers because we were also engineers.
Yeah.
And as the business got better, and with the founding of the Federal Circuit, it brought more uniformity and patents started to be more valuable. Of course, general firms decided, well, maybe we ought to get into this. And for a while, I had kind of a lunch practice going on with friends in general practice firms saying, how do you get an IP group in? So that happened, and it changed the business dramatically. But the, quote, boutique that we are has continued to survive.
Right.
And I think in part because we've gotten along so well. Even though we're more like other firms today, I think there's still a lot of collegiality and consensus building.
There's a lot of debate going on, and it seems to change every year. What's the future of IP practice? Is it boutiques, or is it large general practice firms having an IP group? Do you have any views on that subject in general, not just related to Finnegan Henderson?
No, I don't. I mean, I've seen that happen as well. And what I've seen is good people can do well in a lot of environments.
Yeah.
And if good people want to be in a smaller environment where they're only doing, say, prosecution, they do really well if they're good at it and they know how to run their business. The ones that said, oh, no, I like being in this bigger firm, if they're really good, they're still going to succeed. They still get clients. Some people say, well, they get priced out of the market. The really good ones don't. They pay attention to what they're charging. Right. They become efficient. And so it works both ways. And I come down to good people attract good business. And if you have good business, you can attract good people who will do good work, which will attract good business. And it's a little circle.
For example, if you were advising, I guess, a general counsel at a large technology company, he's deciding what firm to use, a boutique or a general practice firm for his IP work. Is there any advice you would give him how to think about that, or is it really just pick the best lawyer you can find and it doesn't matter?
That's what I would tell them. It's figure out where you'll fit in the best, who will treat you the best, make sure you're not going to be backburnered in a big firm, but if the big firm says, no, we got these people, they're focusing on this. I think you're fine. A small firm, of course, has its advantages in that they can say we're smaller and we're not going to backburner you.
So since Finnegan Henderson has been in existence, lots of IP-focused firms have disappeared. And, of course, I'm thinking about Morgan Finnegan, but also Ken Kenyon, Penny Edmonds, a few decades earlier. Has the disappearance of any one of them surprised you in specifically?
The word is probably saddened. I wasn't so surprised because, well, maybe I was surprised because firms that I thought were the pillars, you didn't mention Cushman, Darby and Cushman. Yeah. They were a fine firm here in the city. I'd interviewed them when I went with Irons Birch and Bernstone, Benedict, Swecker, Mathis. I interviewed them. And they were all really wonderful firms with terrific people. And when one or another of them would go under or would merge out of existence, I would feel bad. And I think a lot of us hated to see the good firms go. And then frequently the mergers would mean some of the partners would leave, and that's always sad. Yeah. So you'd see some things like that. And some of them have been very successful. Some haven't been so successful. But we hated to see the old ones go.
Do you think there are some common mistakes that those IP boutique firms made that they didn't anticipate? Some difficulties that...
Well, I wonder if it's not a question of flexibility. I mean, you've got to be able to compensate your good people. You got to make sure that they're making good money, or they may not because of a few dollars, but when they talk about hundreds of thousands of dollars, they may feel like I've just got to go somewhere else, or I'm going to lose some of my team members. Yeah. And I think we've been pretty good at that. It's difficult. because the senior people need to get out of the way, maybe, and we've done that.
Right.
And so there's points to spread around, and I think it works pretty good for us, but I think that's the stress point. When I see law firms having problems, it's because people are leaving for one reason, and I think mostly it's compensation.
And I don't know, and I think you touched upon it a little bit, but more recently, at least I've seen this trend of these super specialized IP boutiques, even leaving firms like Kirkland & Ellis to just focus on patent litigation, or leaving a big IP firm to just focus on trademark work. Mm-hmm. Are you surprised by that trend, or why do you think that's happening?
Well, I think that's because good people do those things and they want to do what they do well.
Yeah.
And, my view has been that if you want to do well in this business, learn something and learn it well. Yeah. I was fortunate having been at the Court of Claims. That was an arcane court to some people. I had Boeing, I had IBM, I had Sony and Westinghouse. And a lot of that grew out of the fact that I had expertise in how the claims court worked.
Right.
And in those days, that was very valuable to me. I wrote articles on it, but I was also active in the Bar Association and got to know a lot of people. Right. So I knew the patent counsels of these companies that were thinking about, well, what are we going to do now that we've been sued here? And it worked. It worked pretty well. I would go around the country speaking, and most people get that opportunity. And if you do it well, you'll get invited other places, and you tend to meet people.
If you were going to start a new law firm today, what would it be like? What would you focus on? And now it's a much more competitive market. How would you really differentiate yourself?
I think pretty much the same things. Do the top quality work. Project yourself as a top quality lawyer. We always paid our people well, so we had support staffs that were very well paid. We paid in the 75th percentile. We wanted those people to do a good job to make us look good. And be friends, go out and meet people. It's still the way the business works. I used to say you had to call on a client 3 times before they were going to send you work. Yeah. And I think that's still true. The 3rd time you probably get work.
If you had to pick one thing for a law firm to be successful, what would that one, characteristic? I know you mentioned flexibility, but...
Well, I did mention flexibility. I think you have to do top quality work to be successful. Yeah. And a lot of other things can make it much better. Yeah. How collegial you are and how well you get along and how thorough you are, and if you do double checking to make sure you don't make mistakes. But you still have to be really good. And I think of a guy like Don Dunner. He got to be an expert in the Federal Circuit, and he still is. And he still writes articles on it, and he's still asked to take important cases. And you mentioned trademark. I've known trademark lawyers. In fact, some left our firm to establish their own firm. They were well known, and they were able to do that.
I guess the last question about legal practice might be the most important, and you gave a lot of good advice about it. But any advice about getting clients in particular, or in particular getting foreign clients? Any maybe stories about how you...
Well, I think, again, you just get to know people and make friends. People have asked me, how did I get Sony as a client? And Sony happened to have a case in the Court of Claims, but they didn't know me from Adam. But their general counsel of Sony America in New York knew a guy named Art Levine. And Art wasn't a partner of ours in those days, but he was a guru in copyright law. Okay. And Art knew me. So I get this call from this lawyer I'd never heard of in New York saying, will you be free to represent Sony? And I found out it comes from Art Levine. And so it just sort of happens that way. And I think not taking clients for granted. I think when I think of Toshiba, I must have made 30 trips to Japan. I always visited Sony and Toshiba, but I visited Hitachi and other people. Clients love that.
Yeah.
And so you got to go and show them you're interested in them and you like them and you're willing to spend your money and your time, not on their dime,
right.
to see them. And I think that's what works.
It's very helpful. You talked a little bit about how when you first started practicing, it seemed that there wasn't a lot of appreciation for patents and intellectual property rights. But some of that concern, again, that maybe in all this talk about patent trolls and so forth, do you think IP rights are sufficiently appreciated now in the general culture? Does it worry you that they're not? And any thoughts about that?
Well, I think the pendulum at the current time is swinging, sort of anti-patent. And a typical pendulum gets momentum going after the push is over. And I think it's still going in that direction.
Okay. Yeah.
And it needs to come back. I think there are, and as is natural, everybody's representing their clients. And some really big companies that have been sued by a lot of people have been burned and feel like, gosh, I could live without these patent systems. They're willing to fight with their competitors, but small companies would have a terrible time without a patent system. And I think big companies are reluctant to put money into research when they don't know that they're going to get it back out. So I think this will kick back, but I do think the momentum is kind of still carrying this view. I'm still hearing people talk about, well, we got trolls out there, right. But there's multi-millions of dollars to be made in this business, and we don't want other countries to get ahead of us. When the pendulum started to swing back in the late 70s and the 80s, it was Japan that was the rising star. And they didn't have to worry about American patents because they would get held invalid. And if we go back to that, one of the greatest assets our country has is we're very innovative. We know how to do things, and other people may know how to quickly bring that into fruition, but we know how to make it work. Yeah. And if we give that up, it's huge. We will fall behind other countries. So I think we need to be careful and push back against people that say, we don't really need this patent system. I used to say I did a lot of work over the years for GE, and I don't know whether GE would agree, but I used to tell people, GE's got this powerful marketing arm. Yeah. They've got this money to put salespeople in the field. They have advertising dollars. They can compete with anybody without a patent system, head to head. Yeah. But believe it or not, GE always supported the patent system, which was good. But I used to think there's a company that was doing it to help everybody rather than their own little interest.
And their short-term interest, and it seems a lot of companies are thinking that way about the patent system. Right?
Yes, that's right. Well, companies more and more want to have quick returns on the dollars and don't like to see they're paying somebody for the technology they, quote, borrowed.
I heard that Justice Scalia was actually your neighbor at one point. Can you tell us a little bit about what was he like? Did you ever have a chance to discuss patent law with him? Or
I did a little bit. He was a great guy, and I think if you read about him at all, everybody liked him. Yeah. I mean, I never went to play poker with him. I played tennis with him a lot with some of the other judges, and but he was very gregarious, outgoing, and an impressive guy, really. One time my wife got a call from Tom Winland's wife, and Tom's one of my partners. She lived 2 doors down, so she was on the other side of the Scalias. And Tyler said, Tom's out of town and somebody's pounding on my door. And my wife, who was fearless, jumped up and said, Tyler's in trouble, I'm going down. And I'm sitting there thinking, I haven't got my shoes on, let me get dressed. Anyhow, Livy's gone, and she goes down to Tyler's, and I get my shoes on, and I go down. And when I get there, it turned out a man who was having a heart attack in her front yard. Oh. He had been running around the neighborhood, I guess. And when I got there, he looked very dead. And I felt bad about it. But Nino come walking out about the same time I did. And bless his heart, he just kept coming. He immediately fell to his knees and started pounding this guy's chest.
Yeah.
And I thought, why didn't I think of that? But he was fearless
Right.
and willing to do that because he wanted to save his life.
Wow. Yeah.
And that's just the kind of guy he was. I think he was a self-starter, individual thinker, and had a great mind. I could tell you another Scalia story if you're interested.
Yeah.
We had 4 Supreme Court justices in our neighborhood. And when Nino was appointed, it was late at night, and he had been nominated, and now he was before the Senate for confirmation, but everybody loved him, so it wasn't even controversial. But we're watching it on TV late at night, and Rudy Boswich, the senator from Minnesota, was sitting in the leader's seat and running the Senate proceedings. And so we watched, and Nino was confirmed unanimously, and so we go to bed. The next morning I get up, and I used to run around our neighborhood, and I would occasionally see Rudy, and I hated to see him, not that I didn't like him, but he ran faster than I did. But he was so gregarious that he would wait for you. And then suddenly I would get with this guy, and I'm being really stressed the whole way. So anyhow, I see him, and I say, Rudy, what are you doing out here at 6 o'clock in the morning? I saw you on TV at 10 o'clock last night. And he said, what were you watching TV? I said, well, my next-door neighbor was being confirmed. Scalia's your next-door neighbor? Oh, we've got to go and congratulate him. I said, no, it's almost 6:15, but we can't do that. But senators and congressmen are outgoing, gregarious people, and Rudy said, no, we're going to do it. Tell me where he is. So we ran up some hills I never ran up to get to my next-door neighbor's house. I knocked on the door, and there's Nino's wife, Maureen, comes to the door. She's in a nightgown. I can see Nino pacing back and forth behind her. He's in sweats, trying to get a D.C. Court of Appeals opinion done so that he can get to the Supreme Court. But I had to introduce him to Rudy Boswich. So it's kind of a fun story. And he was a great guy to be a neighbor to. He came to our weddings, and we went to his weddings, and hated to see him die. But we had these other folks that lived in the neighborhood. Whizzer White lived there. And I did ask Whizzer one time, because the Supreme Court, I told you, had affirmed the Adams battery case as valid and infringed. But if you look at that opinion, you'll see there's one dissent without opinion, and it's Whizzer White. So at one of these parties at our house, I said, Whizzer, I'm not asking you about any pending cases, but in that Adams battery case, which was probably 10 years old at that time, you dissented without opinion. Could you tell me why? And he said, well, we Supreme Court justices do not understand patent cases. So some people would get a kick out of that today. But I always felt that their renewed interest in patents grew out of the, I shouldn't say renewed interest, their interest in patents grew out of the BlackBerry case. I don't know if you remember that, but BlackBerry was sued, and they had the potential of getting an injunction that looked very real, unless they paid a huge amount of money. So everybody that had a BlackBerry, I had one in those days, Supreme Court justices had them, congressmen did, and the congressmen were saying, you mean that tomorrow they may shut down this server? And I don't think Congress quite grasped it. The Supreme Court was the same way. They couldn't believe that there was something going to happen that through a lawsuit, they could lose their BlackBerry. And I think that's where they became much more interested in what was going on in the patent system. Until then, they were delighted with the Federal Circuit. They took all these complicated cases and they were making uniform law. But I think they thought there must be something wrong if this can happen. And there wasn't anything wrong, but it is what patents can do. And of course, there was never an injunction. BlackBerry paid $350 million, I think, or even more. I'm not sure.
And I believe Justice Scalia said that his hardest decision was a patent case as well. And everybody thinks he was referring to Bilski. So,
Might be. I don't know that. I don't know that. I think I never really discussed cases.
Yeah.
I thought it would, although the justices are willing to discuss them more openly now.
I guess I want to thank you for your time, but I want to end with two questions. If a law student wants to be the next Doug Henderson, what advice would you give them?
Well, my first thought is you've got to be born to Mr. and Mrs. Henderson. If he wants to do well, or she wants to do well, and there's a lot of wonderful women lawyers today, I think they need to get a good education. They don't have to be the number one in the class, but they need to be a people person. Get along with people. That will be your partners that you want to get along with. That'll be your clients that you want to get along with. And don't be carried away with who you are. Be willing to give up rights at times so that others can succeed and watch them. And I think just do your best every day. That would be my suggestion. Certainly, I would like to see them become a law clerk.
Yeah.
And I think if they're not going to be a law clerk, it helps if they have been the editor of their law review. They may not be able to do that, but they can still write articles. And again, get known for being good at something. It's so diverse now, so much in this business, that nobody's an expert on everything.
Right.
When we opened, you could be sort of an expert on everything. I did trademark, patents, and copyright work for a lot of my career. Today, you wouldn't do that because it's so sophisticated. So find an area, become very good at that, write articles about it, let people know who you are, get active in the bar association, and when somebody has a problem in that area, they're very likely to come to that person.
That's great advice. The last question I have is, it seems there's a lot of concern in the IP community these days. We talked about the negative attitude in public about IP rights to price pressure from clients. Do you have any final words of optimism for the IP attorneys in this field?
Oh, I think IP is going to be great. You're going to go through this kind of pendulum swinging thing back and forth over the years. I think we're better organized today, so maybe we won't let it get as bad as it was when we started out. But it's a great business. You stay on top of technology. And if you're interested in history, sometimes your cases go way back in history, so you have the gamut. And I think there's concern today that a lot of companies are under financial pressure and cutting back. But to be honest with you, there was a time when Japanese clients were mostly with firms that had people that spoke Japanese.
Oh, wow.
And when they came to realize that their patents weren't really good, they decided, hey, what we want to do is get good patents, we'll handle the translations.
Yeah.
And I think that kind of thing tells you if companies feel they're not getting the quality work that they need to be able to assert their own patents, they're going to say, we'll pay more money. Now, they may not get as many patents, but they may be willing to spend big money on all of them. It's another pendulum swing, I think. So I think there's a lot of future for young people in this field. I was just talking to a biologist in a doctor's office where she was working as a scribe this week, and told her, look at patent law. You got biology. It's a great field, and it's the field that really let women bloom in patent law, because many of them were biologists in the early days. Now, we got them in all the fields. But anyhow, I remember telling it's a great field and a great future, and you'll do well. And we've been treated well. The Lord has blessed our firm and our lives.
That's for sure. All right, thank you so much. I really appreciate it.
It's nice to be able to talk with you, Eli.
Definitely.